Hi, this is Heather with Bootleg Legal. Today we're going to talk about employment law.
If you spend your money on nothing else, and if you get nothing else out of this course, please get this out of this course. Employment law is likely one of your biggest areas of exposure, particularly if you live in California. And the reasons for this are very complicated, but the short of it is that in California and other states, the courts are going to err on the side of protecting the employee. And what this really means, practically speaking, is that if you terminate an employee, or if you have an employee that's unhappy for any reason that's sufficient to get them into the office of a lawyer, that lawyer is almost always going to take the case, even if it's meritless. I cannot tell you how many of my clients have had to settle completely meritless employment cases because the cost of litigating them would be much higher than the cost of settling them. And these are what we call nuisance value cases, 7 to 12,000 generally. And that's what they get. If you're a terminated employee in California and you, particularly in Los Angeles and San Francisco, it's a little less so in San Diego, and even more remote of a chance up in Northern California where I am right now. Northern, not the Bay Area. But generally speaking, it's a big area of exposure. If you are a large company and you have many employees and you fail to have policies making sure that you're complying with wage and hour requirements and meal and rest break requirements, you could find yourself paying out a lot of money across the board because there are fines that get tacked on for each violation, and then they all add up together. So, few biggest things with employment law. I'm going to try to really boil this down because this is one area, if you're going to spend legal money, this is the area that if you have more than 5 employees generally, that I would at least have an employment counselor on call, labor and employment counselor. But here's some general guidance so that you understand what you're dealing with and when you need to call an attorney. So first of all, the key tenet to employment law is to treat everybody the same. Treat everybody the same. The basis of every discrimination claim is I was treated differently because I am, insert, female, a person of color, gay, bisexual, the list goes on and on of protected classes. But you can't just say, I was fired. You have to say I was treated differently, and it's because of one of these protected classes. That's what it takes to maintain a discrimination case. I can't tell you how many I've represented both employers and employees in these cases. And I cannot tell you how many employee calls that I get that go something like this. I was fired or I quit. It was a hostile work environment. My boss was such a dick. And I'm like, oh, okay. Well, tell me more. Was he a dick because you're the woman or gay or black or whatever? Oh, no. He was a dick to everybody equally. Like, well, believe it or not, you could be a boss and be a dick to everyone equally, as long as you're a dick to everyone equally, right? It has to be because you're in a protected class. So, how do you make sure you treat everybody equally? This is really where the magic of handbooks come in. Having a handbook is not the same as having an employment contract. They're different things. But having a handbook can set up policies that how you handle employee complaints and issues and bullying and reprimand and all of these things. Termination interviews, exit interviews, all of these things. Even entrance interviews are a hotbed of potential exposure if you ask the wrong questions, okay? So the best practice is to have, if you have 5 or more employees, is to have a handbook and follow it. And I'm not talking about a generic handbook that you download or that your payroll company gets you, because those are fine for having a handbook. But if you're actually trying to implement policies tailored to your company and the policies that you're actually going to follow, I would work with an attorney to draft one that actually reflects how you want to run your business and how you're realistically going to run it. Because if you put in there, we're going to follow these policies whenever somebody has a grievance, and we're going to follow these policies, progressive discipline policies whenever you do something. If you put that in there and then you don't follow it, Oh man, all they have to say is they didn't follow it because I'm a insert protected class, right? So have a handbook, have it be reflective of how you actually want to run your business, and follow it, right? Those are the basis for avoiding discrimination and retaliation claims. So retaliation claim is, hey, I reported a violation of law or something else that basically a violation of law, and I was punished for it. I was demoted, I was fired, whatever. And retaliation cases are becoming sort of the new biggest hotbed, I think, even surpassing discrimination cases. So be very careful. If an employee comes to you and says, I don't think you're timely paying my, whatever, this or that, they could be setting up a retaliation claim. I've had a client recently where an employee's just sort of made up a violation, and it seemed very out of the blue. I think he came up and just said, I think, something like, you need to be paying us on the Thursday before the whatever, just something strange that had nothing to do with the law. I think he just misunderstood the law. But then, of course, a few weeks later, I think he knew that there were layoffs coming, and there were big layoffs. And when he was laid off, he said it's a retaliation claim because I was reporting a violation of law, even though it wasn't an actual violation of law. So, be sure that you are mindful when somebody ever does do that, and take it seriously. Tell me why you think is being violated. Let's talk about this. Let's make sure that I am. Talk to your lawyer. Make sure that you are in compliance, right? So yeah, huge area for exposure. So that's covering discrimination and retaliation. And then you've got classification. And this one, to really give you a deep dive, would take probably more time than you're willing or able to spend on it. This is two types of classification. There's employee versus independent contractor. And then once you're an employee, it's whether you're an exempt employee or you're not an exempt employee. Incorrect classifications can have massive implications. They could put you out of business. They can go back in time and assess self-employment taxes going 3 years back, and you're done for, right? So these are very important. In most of the country, there's this multi-factor test for determining whether or not somebody can be an independent contractor or whether they have to be an employee. And no, it's not enough that they say, I agree to be an independent contractor. That in and of itself is not dispositive. It might be considered, but it's not gonna just clean the rest of the slate. In most states, except California, which I'm gonna get to, in most states, there is basically an inquiry of how much control you exercise. Are you setting this worker's hours? Are you telling them when to come in and when not to come in? Are you overseeing their work on a day-to-day basis? Are they doing their work on your equipment and computers? Are they, on call when they're not there? Are you calling them at home and having them do work? Are they working for anybody else? Or are they just working for you? Is it a long-term contract, like indefinite? Or is it a, short-term project that's going to conclude in a month, right? Like a good example is a CPA that does your taxes. And so like once a year, you might hire them for a month to do your taxes. It's a short-term discrete project, which they do on their own, subject to their own license, and they do it for a whole bunch of other companies, right? Versus your in-house bookkeeper who is working with you indefinitely on staff, in the office, day in and day out, year-round, using your computers, right? Those are very obvious examples where, an accountant, might be doing might be able to be properly classified as an independent contractor or an employee. Okay, California, as anybody who lives in California knows, this has been sort of the legal development of the year, passed this new law called AB 5, just went into effect January 1st, completely throwing all of that out and implementing what we call the ABC test. And the ABC test, I'm going to read it to you so that I don't miss any words. In order for a person to be an independent contractor in California, for purposes of wage orders, well, I think that's been changed now, actually, with the new law. For a person to be an independent contractor, the burden is now on the employer to prove all three of the following are true. It's not a balancing test. All three have to be true. Number one, the worker is free from control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance and in fact. B, the worker performs work that is outside the course of the hiring entity's business. This is what got Uber, right? C, the worker is customarily engaged in an independent, established trade, occupation, or business. Like a lawyer, I'm representing lots of clients. No one's ever going to deem me to be an employee of one of my clients, okay? That's what C is about. California is a bit of a mess. If you have any doubts as to whether or not you are in compliance with California's independent contractor employee ABC test, talk to a lawyer. This is one area where it absolutely is worth your money to spend the money to find out, because the consequences you could get 3 or 4 years down the road and have a misclassification claim, and it really could bankrupt your business. It is very serious. So that's the general summary of employment law. But there is so much more to go into because employment law is generally the biggest area of risk and exposure. So in the materials that I'm providing you, I go through, and I have it right here so that I don't forget to mention anything. I go through everything from questions you can and can't ask during an interview, long list, factors that go into independent contractor versus employment status everywhere except for California, hiring guidelines in general, firing guidelines, do's and don'ts basically of firing so that you don't end up getting sued after you fire someone, or you do, but it's frivolous enough to settle it for a nuisance value. And then I have a whole section just on general employee guidance. Okay, so it's a heavy topic, employment law. It's critically important. It varies pretty widely by state. There's so many other issues that I can go into, and I might end up doing a course just on labor and employment law. But in the meantime, this is what I want you to take away. I want you to take away that you need to treat all your employees the same. And you actually need to do some pretty thorough self-examination, self-audit to make sure that that's true. Check your own bias, right? Everybody has bias. Everybody. Find out where yours is and make sure it's not impacting the way that you manage your workers or the way that anybody on your team manages your workers, okay? You're going to need to take complaints very seriously. You're going to want to do if anyone reports to you sexual harassment, discrimination, or retaliation, you are going to need to immediately do an investigation. You're going to want to have an outside party, ideally, do an investigation, or an HR department internally. You probably don't want your general lawyer to do that for various reasons, not least of which that's going to make them a witness down the road when you might actually need them to be an advocate. Do a thorough investigation. Really get into it and interview anyone who saw the occurrences. Take notes. Do credibility. Assess who's being more credible in these interviews. Write that down, okay? And then hear it with an open mind. What I see a lot of the times is when employees come to their managers and they say, I feel like I've been treated this way, the defensiveness trigger just sort of erupts. This defensiveness is fear of getting sued, and I get it because these suits are expensive, right? But a lot of money could be saved and a lot of lawsuits prevented if, number one, companies were proactive about preventing these types of things. And number two, when they did occur, they took them seriously. They investigated them. They took steps to remedy them. They got honest with themselves about whether these issues were really going on. And they took steps forward, right? So take it seriously, not just because it's the law, because it's the right thing to do, you know? You have the power and an employer, if you are the owner of the business, employer-employee relationship. Use it wisely. Set a good example. And, I do have one client who has, at any given time, somewhere between 50 and they're a manufacturing company, 50 and 100 employees. And, I give them my normal spiel, right? For every 10 employees that you have over a 10-year period, you're going to get sued 2 to 3 times at least. It's just the cost of doing business, right? And they look at me and they said, we've never been sued. And And I was so impressed, and I started digging into it. And I think it's because they believe that the law is not the baseline of how they treat their employees, that they want to treat them in a way that they would like to be treated themselves. And they go above and beyond, and they make them feel valued. And so they never get sued. I'm not trying to say that that's possible for everybody, particularly in other industries, but it goes a long way. Being a good manager and a good company goes a long way to preventing employment disputes. However, you're never going to eliminate that risk. So have contingencies, have policies, and follow them. Thank you.